So then let's get started. Welcome everybody again to today's CFWebinar, our, in the meantime, traditional EPO case law update, yearly update on interesting decisions. Last year we divided it into more formal procedural aspects under the new rules and material aspects. This year we decided to divide it by technical subject matter. So 2 days ago, my colleague Matthias Karlhuber and Svenja Schwann presented digital physics, mechanical engineering cases, and today Arvid and I will present our selection of interesting cases from last year from the chemistry, pharma, and life science space. And before we start with a short introduction, let's maybe just attend to some housekeeping matters. This webinar, as you may have already noted, will be recorded. You will also receive a link to the recording and also to the slide deck early next week. So no need to take detailed notes for you. Please, if you have questions, so this is a webinar format where you cannot actively participate by voice or video, but please do interact with us via the Q&A function and ask questions you might have, or make comments, and we'll try to pick them up as we go along. Yeah, other than that, we will also have a couple of surveys or questions for you in the webinar to just loosen up things a bit. Yeah, and the final point is that when we are done with this webinar, when you close the Zoom session, you will be redirected to a feedback form. And it would be really great if you could let us know there, especially what topics would interest you for 2022 to hear maybe a webinar on. Okay, and with this, I think we can get started with the official part. So welcome again for those who have just joined the last minute to today's CF webinar on giving a case law update, EPO, Board of Appeal case law in the last year in the chemistry, pharma, and life sciences space. My name is Nathalie Kirchhofer. I'm a biochemist by training and partner here in the life science group of Coors and Florac. And with me today is Arvid. Perhaps you can introduce yourself shortly.
Yeah. So my name is Arvid Burichter. I'm a patent attorney and partner here at Coors and Florac. I have a PhD in organic chemistry, and just like Natalie, my practice focus is on contentious patent proceedings, in particular EPO opposition proceedings.
Perfect. Yeah, and then having said that, let's get started. So this is just an overview of the topics we've selected today, the pending or decided G decisions of the last year. So video proceedings, pending referral on plausibility, and the double patenting G decision. And then we've selected kind of a couple miscellaneous decisions that we found particularly interesting, and these are in the added matter space, a couple of decisions here. Interesting decision on the requirements or criteria for selecting comparators in comparative tests to show technical effects. And then on a more procedural note, an interesting twist or confirmation in the space of interventions by assumed infringers on appeal. Yeah, and with that, let's maybe turn directly to the first topic. So the G1 of 21 video proceedings decisions.
Yeah, that's really something. Let's start off with this, and this is probably something that most of us have gotten used to over the past 2 years during the pandemic. That is oral proceedings by video conference. Here in the picture, you see Natalie and me in our favorite video conference room. And as you know, oral proceedings before the opposition divisions and also the examination divisions are currently almost exclusively held by video conference before the boards of appeal, we have a mixed picture. Some boards still hold oral proceedings in person, others prefer video conferences, so a mixed picture. Now, most of you will be aware of the enlarged Board of Appeal decision G1 of 21 that issued in July of this year. The proceedings were quite peculiar. In particular, these proceedings were sidetracked by a number of objections to the impartiality of several of the board members. Several of the board members were excluded from the enlarged board, but apart from this sidetracking, the underlying question here was whether the EPC allows for oral proceedings to be held by video conference, in particular in a case where one of the parties does not give consent to this. So if you have a situation where one party wants a video conference and the other party wants an in-person hearing, really the question is what the board or the opposition division or the examination division will do. Now, the original referral question was quite broad. If you look here at the top left of this slide, this was the referral question. The enlarged Board of Appeal, and really it boils down to any hearing, can any hearing be done by a video conference without the consent of the other party? But now the enlarged Board of Appeal did not answer this question in this generality, but it reformulated the question so that it is limited in two aspects. The first aspect is it limited the question to really hearings before the Board of Appeal. Yeah, not first instance, only Board of Appeal hearings. And the second limitation the board made the enlarged board made is it limited the question to hearings during a general emergency. So specifically to the COVID situation. So it didn't answer the question in its generality, but it limited the answer to this situation. Now and you see the reformulated question there on the bottom of the past slide. Now the decision of the enlarged board is interesting to read. First, in reason number 38, the board comes to the conclusion that a communication by video conference is not the same as a communication in person. Right? That's the first important finding the enlarged board made here. And second, in reason 45, the board says that the gold standard for any oral proceeding before the boards of appeal should always be an in-person oral hearing. So really, the in-person oral hearing should be the default. Now, and only under very special circumstances, a party can be denied to attend oral proceedings in person, and such special circumstances the enlarged board sees in a general emergency, just like the COVID situation. So, and finally, the board, the enlarged board decided that the decision to deny an in-person hearing is a discretionary decision of the board that holds the oral proceedings. So really, bottom line here is that during a general emergency like COVID-19, the board can conduct video conference hearings also without the consent of the parties. What will happen when COVID is hopefully over someday, we don't really know yet. But the way that we read this is that there must be very, very special circumstances in order for a board to deny an in-person hearing without these, extraordinary situation.
Yeah.
Now,
but at least right now they are also really practicing this. So we also have even cases where both parties requested oral proceedings to be postponed and not held as video proceedings, where the boards now proceed in December hearings with forced video proceedings against the consent of both parties, referring to G1 of 21.
Right. Yeah. And really, right, Natalie, our experience is very mixed. I mean, some boards seem to prefer in-person hearings still also during the pandemic. Other boards really prefer video conference hearings. It also really depends on the board which handles the case. Very, very specific. Now,
and what's also still entirely open is the situation in first instance, right? So the G1 of 21 is really limited to the appeal stage, and that's something we will follow very curiously if the EPO president might not decide that maybe for the first instance it's different. Maybe the default will stay with video, and you need to request oral proceedings. So that's something one should definitely follow in the next year.
And really, in general, I would say we have made very good experiences with video conference hearings, and we think that these work well for many cases. They're very convenient. They are very efficient. The technical setup is if it's done right, you have a excellent quality. But there are also situations from our perspective where we still have a preference for an in-person hearing. And in particular, these are complex cases with many documents on file or multiple party cases with several opponents. In my view, these are difficult to handle by video conference. And especially, at least my experience, but I think you have a similar experience there, is when you have to turn around a negative preliminary opinion. My view is that it is still easier to do if you have the persons in front of you than by video. It will be interesting to hear your experiences. And for that purpose, we have prepared a little survey. Natalie, maybe you can start that survey.
Yeah. Actually appear on your screen now, so maybe just answer spontaneously by your gut feeling. So the question is, what is your opinion on video hearings before the EPO boards of appeal? Are you generally against video hearings and think oral proceedings should take place in person? Do you think video hearings make a lot of sense but should not be against the consent of a party? Should the EPO and boards of appeal be able to also force video proceedings on participants? And the fourth option, do you think the EPO and boards of appeal should switch completely to video hearings? So let's just wait a couple of minutes more. I see, there's a lot of participation. So around 80% of you have already given their vote, and I'll end the poll now. And share the results with you. So you should see them now. And it's a relatively clear picture, right? So it's similar to our view, I would say. So around 80% of you do agree that video hearings make a lot of sense, right? But that it should be at the discretion of the parties. That's an interesting result, but also reflects our
absolutely.
Okay. Then let's turn to the next topic, and that's the pending plausibility referral. So right now, before the enlarged Board of Appeal, there's only one referral pending, and that's the G2 of 21 referral, which is super fresh, just occurred in the last couple of weeks. And this referral is very important for the chemistry, pharma, life science space because it addresses the question of plausibility and which standard should be applied here. And just as a quick introduction, plausibility is not laid down in the EPC as a patentability requirement, but it's a concept purely developed by the case law. And in essence, it says that you should only be able to claim inventions or rely on technical effects if at the filing date in your application as you filed it, you at least already rendered it plausible that this technical effect indeed is associated with your invention, or that you were in possession of the invention. So it's supposed to avoid or put a bar to purely speculative patents. It's especially prominent in the life science and pharma space, because there very often the inventive step hinges on the question of whether or not a special technical effect is associated. It's also particularly relevant for the life sciences and pharma cases, because here we all often have applications with experimental data in the application, and that's for plausibility always a big question. How much data do you need to put into the application, and what's the ideal filing time point? So how much data do you need to acquire before actually being able to file a patent application? And yeah, it has drawn a lot of attention, the plausibility issue, also from big UK litigation cases, where in the UK there's a whole line of jurisprudence and group of judges who promotes their very strict interpretation or strict assessment of plausibility, and where a lot of pharma patents are invalidated.
Even stricter than the EPO, often, right?
Are invalidated on the basis of lacking plausibility. I already said there's no express basis in the EPC, but plausibility comes up either under sufficiency of disclosure, so Article 83, or inventive step, Article 56. And the question under which provision the question of plausibility arises depends on whether the technical effect is mentioned in the claim or not. And that's particularly relevant for pharma cases, for second medical use cases, because there the medical indication is seen as a functional technical effect or feature in the claim. So that's why in the second medical use cases, plausibility always pops up under Article 83. In more classical chemistry cases, it usually pops up in the problem solution approach when the question of technical effect arises, and when patentees start to rely on experimental data that was not included in the application as filed. And usually there's a two-hurdle test. So the first hurdle is just this plausibility hurdle, so just the question of whether the application as filed, and really only the original application, whether that renders plausible the technical effect you're relying on or you have in your claim. And once this hurdle is overcome, then there's a second assessment on whether actually Article 83, so sufficiency of disclosure, is fulfilled, or whether actually the data that can then be taken into account, so post-filed data, post-published data, whether that actually shows the technical effect. So it's always, and it shouldn't be confused. So the plausibility standard is definitely a much lower standard than the standard for Article 83 or 56, because it's only this very first hurdle that needs to be overcome. But the big difference is the first hurdle you need to overcome based on the application as filed. For the second hurdle, once you've overcome the first hurdle, you can rely on data that was not in the application.
And I think one of the most prominent examples, which was very controversially discussed, was the Sprycel decision, right? The Bristol-Myers Squibb's drug Sprycel, the compound patent for that was revoked by, I think it was Board 3301, in what we call the Sprycel decision, for lack of plausibility, despite this was an approved drug, right? So there was plenty of course, data available for the efficiency of the drug, but it was nevertheless revoked because there was not enough data in the application.
Yeah, on no actual
in that
data.
Case, no actual data.
But just a statement towards the activity, but no actual activity data. And so the current referral is from Board 3302, so not the Sprycel-Lindner 3301 board, but Board 3302, that's chaired by Markus Müller. And the T decision that just came out with the referral reasons is T116 of 18, which is really worth a read and summarizes the current situation. And what the board here has identified is that currently there are diverging lines of case law, so diverging standards depending on which board you are facing. You have different standards of plausibility, and that's now the reason for the referral. And the board here has identified 3 different categories or lines of case law. And the one on the very left, that's the T488 of 16, that's the Spreisel case. So that's the very strict hardliner standard, where, and Müller called this here an ab initio plausibility scenario, where it has to be plausible from the application as filed in combination with common general knowledge that the technical effect that you're relying on was indeed achieved already at the filing date of the patent application in question. And here the burden of proof is on the patent proprietor to show it. So that's a relatively high burden. But then there's a whole bucket of other decisions which apply a less strict standard, and which in effect say it's the other way around. Generally, the burden of proof is on the opponent, and the opponent needs to show that there's an ab initio implausibility. And once this is then shown, then the pendulum shifts again to the patentee who needs to argue plausibility. So that's a very, very big difference here, right? Whether you're asking, well, is it really prima facie ab initio implausible? Are there reasons why one would think it's entirely implausible that this invention would have worked at the filing date? That's a different question from saying you have a burden of proof to really show that ab initio this was plausible. And then there's a third bucket of decisions where Müller identified at least 2 decisions that actually state that in the EPC there is actually nothing said about plausibility at all, and that there's no legal basis for the entire plausibility requirement. So that's what is now up to the enlarged Board of Appeal to decide what the standards what standards should be. So
very applied. Different handling by different boards, right?
Yeah. And just by way of background, the actual case that came before the board here is a Syngenta case regarding an insecticide combination patent, so a classic combination patent of 2 insecticide components, which the application says have a surprising synergistic effect. The one is identified in the claim, thiamethoxam, and the other one is just specified by way of a relatively broad Markush formula. The original application included 2 examples to 2 specific combinations. So thiamethoxam with one and with another compound. And the question now is whether the synergistic effect has been rendered plausible by the application as filed for the entire claim scope. And that's now a question also of burden of proof. So initially, do these 2 examples, is that sufficient? Who has the burden of proof? But then, of course, as always in these cases, the patentee filed additional data to support the breadth of the claim. So there the question is, can the board take this later submitted experimental data into account, and the board performs a problem solution approach with and without that post-file data, and comes to the conclusion that if it were allowed to consider the additional data from the patentee, it would acknowledge an inventive step, and if not, not. And that's why this question of whether post-file data can be considered in this case is really decisive for this case. Between the lines, one also reads a bit that the board may also be concerned that there's somehow a little bit of an imbalance, in this case in particular, that the opponent can always rely on post-filed data. So he can always create experiments of his own, run experiments to show that the invention doesn't work. But here you're now in a situation where the opponent can run all sorts of experiments to show that the invention doesn't work. But this very strict ab initio plausibility standard would prevent the patentee from performing experiments and submitting them, having them considered, that shows that the invention works over the whole scope. And that seems to us to be something that particularly bothered Mr. Müller and the board here, and which we also feel that there's something to it, that this is not this concept of free evaluation of evidence that you otherwise have. So with this backdrop come the actual referral questions, which I think if you read them without this knowledge, they could have been formulated a bit clearer. But the important thing here is the questions 2 and 3, which in principle ask the enlarged board whether this ab initio plausibility standard applies, or question 3, whether the ab initio implausibility standard should apply. And this, in our opinion, is really super interesting, important development. It's good that this has been brought now before the enlarged board.
Yes, absolutely.
And we are very curious to see now also what amicus curiae briefs will be filed and how the enlarged board will decide. Given that it's the only referral pending right now, we can be pretty sure that a decision will likely take place next year.
Yeah. This will definitely be one of the most important decisions, right, in the chemistry life sciences field in the next 12 months.
Okay, and on the following 3 slides, we just picked out a couple of interesting positive plausibility decisions, because they're really, maybe it's also due to the fact that we often represent patentees in opposition cases, so we are always a bit relieved or on the lookout also for positive cases, because one has to say there's really, I mean, a plethora of decisions where especially second medical use claims are invalidated by especially board 3301, also based on lack of plausibility. But this one here, T966 of 18, for example, is a more recent example where plausibility for a second medical use claim, here for the treatment therapy of Lewy body diseases, a relatively broad claim, was considered sufficiently disclosed and inventive based on an application which only included preclinical data, and also the data quality was highly criticized because it was actually only 4 mice that were analyzed, and there was no measure of statistical significance and so forth. So not kind of publication standard data, but still the board considered here the preclinical data in the application, importantly, in combination with the common general knowledge to render the claimed invention based on the application plausible. And that that brings us to this question, or what's sometimes also called the plausibility obviousness or plausibility inventive step squeeze, and whether that actually exists. Because this can, of course, also sometimes backfire, right? If you need to rely so heavily on common general knowledge and prior art knowledge to say that what you're claiming is plausible, opponents tend to often then turn it around and say, well, actually you're saying it's obvious. So based on that same prior art, it should also have been obvious. So that's something to look out for patentees. And for example, in this case, the appeal was, I mean, the patent in first instance was revoked for lack of sufficiency, and the board here lifted the first instance decision, but remitted back to the first instance. So Article 56 has not yet been decided in this case, and it will be interesting to see whether patentees' arguments will backfire in the discussion of inventive step. But there are also now very clear cases on file that one can refer to. At least we thought this was a very welcome decision also by board 3302 Müller, who now also made the referral. That's T184 of 16, where he really head-on addresses this question of whether these plausibility considerations actually are the same, so the reverse side of the same coin as obviousness, and he says, no, plausibility and obviousness are different tests, and yes, it is possible to establish plausibility on the basis of prior art knowledge without that somehow automatically leading to an acknowledgement that the claim subject matter must have been obvious. So that's, in our view, really a good decision to cite. This is another decision of this year, T215 of 20 from a different board, which is also rather positive on plausibility, breadth of claims, and the requirement for data in the application. And here the board has formulated this head note, which reads quite clear and well, so that this general statement, claims in patent applications typically involves generalizations, and generalizations always inherently include an aspect of speculation. And it makes clear that this is not different in the field of medicine. So the mere fact that it involves an element of speculation is not yet a reason that it's prima facie implausible. So that's definitely also a board that takes on this ab initio implausibility standard, as you see here, right, from this prima facie implausible. It was also an interesting decision because it concerned a case where the application, so it's here about treatment of two related diseases, asthma on the one side and COPD. And the application is filed only had examples for the treatment of COPD, while the claims no longer included COPD, but were directed to the treatment of asthma. So that's why here now the question is whether examples in the original application, which actually do no longer fall under the granted claim, can these examples render plausible also the subject matter of the granted claim? So it's like a shift in subject matter. That's also something a lot of opponents raise, right? If you limit your claims so that examples no longer fall under the claims, a lot of opponents immediately react by saying, well, now you cannot rely on these examples anymore at all. This is a nice decision saying, again, in combination with the common general knowledge, if it's known that there's, for example, a mechanistic link between COPD and asthma, then yes, these COPD examples can also establish plausibility for the claims directed to asthma. So also this one is a decision which patentees can refer to in the future, and which serves to clarify this issue.
Absolutely. And one thing that's also important to mention and to keep in mind is that plausibility is not only something that is dealt with under inventive step, but it's equally dealt with under sufficiency. You want to comment further on that? I mean, in which situations do you deal with it under sufficiency and in which situations under inventive step?
Yeah, I mean, I think I already pointed it out in the outset, right? It's this question whether the technical effect is in the claim, or not. So also for the Spreisel case, there are actually two Spreisel decisions, one dealing with it under inventive step for the compound claims, but for the second medical use claims, it's then dealt with under Article 83.
Right, yeah. It's something that's very often confused, right? Most people only relate the topic of sufficiency to inventive step, but it equally applies to sufficiency.
Okay, before we turn to double patenting, maybe let's launch a second survey, just to keep you awake. So again, just your gut feeling answer, spontaneous answer. What is your view on the plausibility requirement of the EPO? First answer, the EPO should revert to a less strict standard on plausibility. The EPC does not even require an application to contain a single example. So that's more the German view. Or are you in favor actually of a more strict standard on plausibility because applicants should include data and it should be made sure that patent applications are not filed based on mere speculation? So let's see what you are answering there. Yeah, seems to be a bit more difficult, the question here. So it takes longer. We're now at 60%. So I'll give you a couple of more seconds to complete. And now we are hitting, hitting the 70%. So I'll end the poll now and share the results. with you, yeah, and it's relatively mixed, but actually a majority is in favor of a strict standard on plausibility. And I've also, yeah, discussed this with a lot of people that I have a lot of respect for, also who
Yes.
also share this opinion, also
Absolutely.
in the pharmaceutical field,
yeah.
Who say that they themselves always tell their inventors, we need data, we wait until we have enough data, and who really do not like these Sprycel type applications where you don't have data.
Right.
Yeah.
I mean, it's always about finding the right balance, right?
Yeah.
Between early filing and enough data. And for that purpose, it's really important to understand the reasoning behind plausibility decisions.
Yeah.
So this new referral is definitely something to watch out for.
Yeah. Okay, then let's turn to our next
double patenting
decision.
Double patenting. Yeah, this is another very interesting and large Board of Appeal decision that issued this summer, and that is G4 of 19 on double patenting. To give you some background on this, as most of you will know, there are no explicit provisions in the European Patent Convention prohibiting double patenting, so two patents with the same scope. However, there are double patenting provisions in national patent law of many contracting states, and also the EPO. The EPO's established practice is to refuse the grant of two patents with identical scope. And this is set out in the guidelines, Part G, Section 4.54. Really, the requirements are that you cannot, the general rule is you cannot have two applications that have identical claims, the same filing or priority date, and that designate overlapping groups of contracting states. Right? This is the general rule set out in the guidelines. And in such case, also set out in the guidelines, the examiner will ask the applicant to choose only one of the applications, or to amend the claims, or to amend the designated states, right? It's also possible to withdraw designated states, so to remove any overlap. Now, the normal way out is to amend the claims, obviously. Otherwise, if the applicant doesn't do that, the applications will be refused.
And I guess the emphasis here is on identical.
Identical.
Right? It already says in the guidelines, identical.
Right.
Which I think is important.
Right. That's very important, and we'll get to that in just a minute. Now, in its reasoning for this practice, the guidelines refer to an obiter dictum in the G decisions G1 of 05 and G1 of 06, saying that an applicant has no legitimate interest in proceedings leading to the grant of a second patent for the same subject matter is the important keyword here, if the applicant already possesses one granted patent for that subject matter. Yeah. Right? This is the underlying reason also cited in the guidelines. Now, next slide, yeah, perfect. Now, in this most recent case on double patenting, G4 of 19, the situation was as follows. The applicant, that was Nestle, filed an appeal against the refusal of one of its applications for double patenting. The application claimed that was refused, that application claimed the priority of an earlier European patent application. The earlier European patent application was already granted. And the special, and this is now special about the case, the claim 1 of the granted patent was identical with claim 1 of the subsequent pending application. Now, the examining division, following the guidelines, refused the subsequent application under Articles 97, paragraph 2 and 125, saying that the applicant has no legitimate interest in pursuing both patents, right? Now, on appeal, interestingly, Nestle argued that it indeed had a legitimate interest in the later application because the later application, filed 1 year after the priority application, has a longer lifetime than the priority application. So this was the reasoning behind, this was Nestle's argument. Now, next slide. Perfect. Now, this case landed before Board 3301, chaired by Albert Lindner. And he referred, or that board referred the case to the enlarged Board of Appeal with 3 referral questions. We put down the questions here for your reference. There were 3 questions in total. And we also put down the answers down here for you, for your reference. Now, for the sake of brevity, I will not read them aloud to you, and I'll jump right to the conclusions. Maybe next slide. Perfect. Really, in essence, the board, the enlarged board here, confirms that Article 125 provides a legal basis for refusing European patent applications for reasons of double patenting. The board, in its reasoning, really relies on 2 reasons. First, it relies on the fact that double patenting is an established legal principle in a number of contracting states. And secondly, it also relies on the preparatory documents. When the EPC was prepared, the so-called travaux préparatoires. My French is not, I hope I pronounced it right. The travaux préparatoires for Article 125, which specifically addressed back then already the question of double patenting. Now, it then found that the double patenting concept equally applies to all scenarios. So it applies when you have 2 parallel applications filed on the same date, when you have 2 applications, 1 parent and 1 divisional. This is probably the most typical scenario. And also when you have 2 applications, 1 claiming priority of the other. So for all 3 scenarios, the same principle applies, the prohibition of double patenting. No differences between these scenarios. Now, and in this decision G4 of 19, the enlarged board also sets out the requirements for a double patenting rejection. And that is, you need to have the same applicant on both applications. That's important. Both applications must be directed to the same subject matter, whatever that means. They didn't clarify that because they didn't have to decide on it, because in this case, the claims were 100% identical. So unfortunately, this would have been the most interesting thing about this whole decision. But unfortunately, the decision is silent on the question what the term same subject matter means. Now, the further requirement is both applications must have the same effective date. And finally, both applications must have the same or overlapping territorial scope, so designations.
Yeah. And I mean, I think what the board, I don't know if they already had it in mind when writing the decision, but for me, an interesting question is now regarding the territorial scope, whether now that the UPC comes into force, whether that might be a sufficient legal interest if you decide to go with one for a unitary patent, opt out the other, whether that would be regarded, I mean, territorial scope really just by territory or maybe by jurisdiction also, right? That's definitely also an interesting aspect.
Yeah. I mean, the decision is silent on the question of same subject matter, but nevertheless, if you read the decision, G4 of 19 draws a very clear distinction between double patenting on the one hand and double protection on the other hand. And the board explains that double protection means claims with overlapping scope. So they differentiate between double patenting and double protection. And this is interpreted by many as an indication that claims with overlapping scope do not trigger a double patenting objection. So as long as the claims are not identical, right? But I mean, this is speculation, but I also agree with this interpretation. But I mean, of course, we can't be sure, but it looks like that this is the general understanding here. So really, in conclusion, G4 of 19 does not contain any surprises. It really largely confirms that the current EPO practice set out in the guidelines with regard to double patenting. It's unlikely that you will run into a double patenting problem if your claims do not have identical scope. Just a mere overlap in claim scope normally does not prejudice the grant of a patent, and there is plenty of case law on this. And you can actually find a very nice up-to-date summary of the existing case law in decision T318 of 14. That is the underlying decision for G4 of 19, right? Very nice 5-page summary of more or less all available decisions. And if you look at these decisions, you will find that 95% are in favor of the concept that unless you have identical claims, double patenting does not apply.
Yeah.
Now,
okay.
Yeah. Now, maybe one side note here, one practice tip. One thing to watch out for is dependent claims, right? If you have a scenario where, for example, you have a parent application with a claim to a species, so a particular chemical compound, and a divisional application with a claim to a broader genus, you should make sure that in the divisional application, you remove any dependent claim directed to the species, right? Yeah. Because this is where we often get double patenting objections. The solution is simple, just delete the dependent claim on the species.
Yeah. And we actually have one question, also a very good question,
yeah,
by one of you, which I also thought about asking, is whether in this case, could Nestle have circumvented the double patenting prohibition by transferring one of the two applications to a subsidiary, right? Because, I mean, in the guidelines, at least it really says same applicant. And indeed, I mean, that would also be a workaround possibly for this UPC unitary patent
Absolutely.
situation.
Yeah.
I mean, there it's always a bit the question whether this transferring to a subsidiary, I mean, there are other cases where this plays a role,
right,
as well sometimes where
with SPCs.
With SPCs, for example, yeah, where sometimes this is not considered legally appropriate, valid approach. But I mean, if you can credibly argue at least some reason for doing that, and if it's
Absolutely.
really a different subsidiary, why not? I mean, that's definitely one of those exceptions.
Yeah, yeah, yeah. And maybe, maybe just one final thing about the double patenting issue. I mean, we also looked at recent decisions, so decisions that were issued after G4 of 19.
Inside G4 of 19.
Inside G4 of 19, and really to see if any practice has changed, right? And the answer is no, the practice has not changed. For example, in T943 of 17, which is very recent, just a couple of days ago, it clearly stated that overlapping claims are not a problem.
Yeah.
And interestingly also, T98 of 19, which notes that G4 of 19 is, of course, clearly limited to examination proceedings, right? Not opposition proceedings, because as you know, double patenting is not a ground of opposition. Yeah. So in opposition proceedings, this is not an issue.
Yeah. Okay, then let's spend the last 10 minutes on this final block of kind of miscellaneous decisions that we thought would be worth pointing out to you. And the first group of decisions regards this very EPO-specific topic of added subject matter. You will
cherry on the cake.
Yeah, will be aware that the EPO internationally in the comparison has a very strict standard on what constitutes added matter. So if you amend the application, especially the claims, right, you need to show that there's a direct and unambiguous disclosure of exactly this amended embodiment in the application as filed. And they're a really hot topic right now, at least that's our feeling from also having talked to some chairman of the Board of Appeal, is this question to list principle selection from lists, but when the lists are actually lists of convergent alternatives. And then there are two more specific aspects that we want to go into. But let's maybe turn to now the first added matter topic here, and that's this concept of converging lists. So I'm sure you're all aware of the so-called two-list principle that the EPO applies both in its novelty assessment vis-a-vis prior art, but also regarding added matter. And that concept says that if you select features from two independent lists, then this combination of features is a new selection, or conversely adds subject matter. So you're not allowed usually to combine selections from two lists if the lists are of some length, but there are also very strict decisions saying even from very short lists. Yeah? But what has come up now in the past years, and there are really certain boards and opponents which propagate this a lot, is that suddenly all sorts of things become lists. Yeah. So, for example, dependent claims become lists. So if you usually would say you have a dependent claim 6, you combine it with claim 1, and then you combine it with something of the description. There are opponents that will say, well, selecting dependent claim 6 is actually a selection from a list of 20 dependent claims. These kinds of arguments. So far that we haven't seen that boards follow this, but originally in the same category for us were these arguments that also lists of different preference levels, right? So when you say, you know, preferably you have 1 to 50% iron, more preferred 5 to 45, even more preferred 3 to 10 to 20, that these sorts of lists of converging alternatives, so that's what the boards here call convergent lists, that these are now also considered lists by some boards. And if you then combine two selections from these lists, you violate Article 123.2, and this happens super quick. So especially in like composition type claims, I'm thinking of, we have a client in the polymer space where we have a lot of blend claims where it's about the composition of the individual polymers. Yeah, where you have polymer A, B, C, different weight ranges, and that happens super quickly that you, for various reasons, combine or limit the weight ratios. And then you have these opponents saying, well, that's a selection from two lists. And there are indeed, that you see here on the left in the table, there is really a whole line of jurisprudence which actually follows this and says, yes, these combinations are undisclosed selections. They create new subject matter, and it violates Article 123. Some of these boards even go so far and say, it's also about the level of preference. So in a lot of cases, if you have a very systematic patent attorney drafting the application, you will always have, preferably, more preferred, most preferred, so 3, yeah? And then some boards even say, well, what might be disclosed is that you always combine the middle preference level, but what you cannot do is combine the least preferred for component A with the most preferred for component C. And all sorts of very peculiar reasonings in these decisions on the left. And then on the other hand, you do also have decisions that do not follow this and say that you are allowed to make select, or that it actually doesn't constitute in a selection in the sense of this two lists principle when choosing one of the preferred options. And here a really interesting case is this, also we would say probably a new leading case, is this T1621 of 16, which has really been emphasized and highlighted as one of the few added matter decisions that has been included in the EPO Board of Appeal case law supplement, right? So that's what comes into the case law book. You might be aware that it's published only every 3 or so years, but the EPO every year brings out this supplement for decisions that will end up in the case law book. And here T1621 of 16, I think it's discussed over 1.5 pages. And it concerns exactly this question of whether a list of converging alternatives is actually such a list under the two list principle. And it's a rather moderate decision, so favorable for patentees, saying that, so in the head note 1, that in principle, a selection of such from such a list is not a classic arbitrary selection. And then in head note 2 addresses the question whether perhaps still multiple selections from such lists might create new subject matter. And this board proposes, in an attempt maybe to bring together again the case law, it proposes a specific test. And it's a two-pronged test. Under A here, the first question that you should ask is whether the subject matter resulting from these multiple selections, it should not be associated with an undisclosed technical contribution. So that's a very peculiar criterion. And then the second one, that's more the one that one already knows from these positive decisions on the previous slide, is that the application is filed should include a pointer to the combination. But actually it's not a pointer as you would usually imagine, like a clear pointer. What they mean by a pointer, or what they would count as a pointer, is already the fact that at least some or majority of the examples still fall under the selection, which usually is fulfilled. I mean, that's why you usually do this preferred, more preferred, most preferred, because you narrow it down to what you actually have shown. And in this case, actually only 7 of the 21 examples still fell under the combination, which they considered sufficient. But it turns out that especially this first criterion, so whether or not this technical contribution and whether that was disclosed, so that again rings a bell, like plausibility or technical contribution rings a bell from the disclaimer space, where you have a similar requirement, right? Where the disclaimer should not make a technical contribution. That's a very strange concept to apply now under Article 123. And indeed, board chairmen have informally commented on this decision to us, but there's now also one concrete decision out there, and that's T1397 of 17 from July. The written decision just came out, where board 2306, so that's chaired by Harrison, really clearly declared its dissent with this first criterion, clearly stating also in a head note that this technical contribution criteria should not be followed. And that the only thing that counts is the gold standard of direct and unambiguous.
Interesting, because this is a board 2306 is a mechanical board, I think, if I'm right. And the 3306 is chaired by Mr. Schwaller, right? A chemical board.
Well, yeah, but I mean, if we would need to bet on what could be a possible next referral, this is definitely one. And indeed, we also had already 2 cases where we ourselves tried to refer this question with the convergent list to the enlarged board. So far, it didn't work. But I mean, now that there are really diverging decisions out there, we do believe that one of the next cases might be used to refer this. Yeah. And maybe because we've just dealt with it, we can just maybe also hear your opinion on the added matter. Again, a very quick survey. So what's your opinion on the EPO's added matter standard? Do you think it's too strict? making it increasingly difficult to admissibly restrict claims for patentees? Or are you maybe in favor of the strict added matter standard? I mean, conversely, on novelty, it's of course always great before the EPO that you can easily be
two sides of the coin, right?
Two sides of the coin. Yeah, but I think I can, although we are only at 60%, I think I can stop the poll because it's a very, very clear result here and shared with you. So you see here that really overwhelming majority has the impression, and that's also what we hear from our foreign colleagues and a lot of clients, that they increasingly really have difficulties to understand what the EPO is doing there with the super formalistic approach.
Yeah.
Okay. Then just quickly wanting to alert you, and I see that we are running a little bit late, but I think it's really only 2-3 minutes more. This concept of the subclass trap that's next to this converging list is a second topic that we really often encounter nowadays, and which is also a very specific and dangerous trap for the chemical field. And this trap goes like this. You have a granted claim, and it's the Article 123.3 trap. So it's in opposition, the question whether you extend the scope of your patent by amendments to the claims. So it usually concerns composition claims where you have, for example, weight percentage of a broader term like metal. And then in the application, it says, you know, preferred metal is aluminium, and the whole examples are all with aluminium. And so you want to restrict the claim to aluminium. And what a lot of patent attorneys do, they just strike out the term metal and put aluminium there. Yeah? But when you actually think about it, indeed, that is a violation of Article 123.3. Because the new claim, the amended claim, requires 1 to 10% aluminum, but it allows undefined amounts of other metals. That's why the correct way to amend such claims, and that's here in this leading decision T1360 of 11 puts clear that that should be allowed, is to leave this 1 to 10% metal in the claim and then specify on top, in addition, and wherein the composition contains 1 to 10% aluminum. So that's reads a bit weird or like double redundant language, but in fact it is required to maintain the granted claim scope. And here we just wanted to point out that there is movement in there. So this is T2447 of 18. Is a case where you see that the devil lies in the detail. So if you're on the opponent side and a patentee does this, to formulate a claim in this way, this was a decision where such an amendment was not allowed because the board in this case considered, definitely the wording not having been disclosed, but also then the embodiment. So the combination of the broad genus with then the same numbers for the species was not disclosed. So we think that's definitely something to watch out for if you're attacking patents under added matter, but also especially when you see auxiliary requests being filed, to really make this check of Article 123.3.
Yeah.
And final point on added matter is this broader dependent claim case, which we also found interesting because it's a case where curiously you had a granted claim 1 that said, particle size was in there at least 20 nanometers, and then you had a dependent claim that specified a broader range, at least 15 nanometers. So in principle, it's a drafting defect, but we also see that often in FTO analysis, what you do with these drafting defects, because they occur actually quite frequently when the dependent claims are not properly checked or amended. What is the scope of that patent? Because what the patentee did here in opposition combined claims 1 and 3. So suddenly claim 1 read at least 15 nanometers. And the question was, is that an extension of the scope of the granted patent? And here the board said yes. With a rather convincing reason. Okay. And the final two decisions that we want to point out to you, because they do seem relevant in especially the chemical space is here one regarding comparative tests. That's also something that we deal with all the time, especially with compound patents or Markush type patents, where for inventive step, you need to show improved properties, or that's then the invention, that you have improved properties. And then there's often in opposition sometimes a big data fight, how this improvement is shown. And then the opponent comes with examples where the improvement is not seen. And yeah, there's this clinch of opinion. And of course, you can try to discredit the other party's data. But what's also important is to actually check what comparators were used. And there are some opponents and also boards that sometimes give this impression that actually the patentee has the burden of proof to really show that the entire claimed compound scope, so that's here in orange, that each and every one of these compounds is better than each and every one of the prior art compounds. And here we have now a good decision clearly setting out that this is not the case. So you actually should really only look to the closest comparator. And that's here this T41 of 16, a German decision. We put here the catchword in English translation, but where the board clearly set out that yes, you need to show the improved effect over substantially the entire claimed range, but this does not mean that each composition encompassed by the claim must be an improvement over any or even the closest composition. Rather, corresponding compositions that differ only in the distinguishing feature should be compared, and these must show the effect. So that's really a good and clear decision, and allows you maybe to scrutinize also your counterparty's data again with this question whether they actually chose the right comparator. Yeah, final slide. Back to you, Arvid.
Oh, now if you spare 2 or 3 more minutes, then we'll be all done. Now, this is our final topic for today. These are some interesting cases that we came across recently. As you know, as an alleged infringer, you have the right to join an existing pending opposition proceeding by filing a notice of intervention under Article 105. You must do this within 3 months from the institution of infringement proceedings that is set out in Rule 89. And you can do this at any time of the opposition proceedings in first instance, second instance, even at a very late stage on appeal. This was set out in G3 of 04. And now there have been 2 interesting recent decisions that clarify that even if the intervention is filed at a very late stage of appeal proceedings, the intervener can submit any new evidence that he or she wishes to file, right? The board has no discretion not to admit such evidence into the proceedings. And these are decisions T1665 of 16 and T2034 of 18. And interestingly, the same also applies to the response to the intervention, right? Also here, the board has no discretion not to admit any documents that were filed in response to the intervention. This was decided in a very recent case in which we were involved, and that is case 1732 of 18. Here the board decided that it has no legal basis to refuse any new documents that were timely filed in response to the intervention. And this is something that must be kept in mind, right? Both for in the mind of the alleged infringer, the intervener, and also in the mind of the patentee, because of course, by filing an intervention, the intervener may give the patentee the opportunity to introduce new material, maybe new experimental results, maybe new documents, post-published data, whatever, at a very late stage into the appeal proceedings, right? And on the other side, by suing someone just before the end of opposition proceedings, you will, of course, also give the intervener, the alleged infringer, the opportunity to introduce new prior art, new experimental data into the proceedings. This should be kept in mind, and we thought these decisions are very interesting in that regard.
And not only new prior art, but I mean, you pointed it out, right? Also
refile,
refile prior. I mean, that's a big thing, right? Because now with the stricter rules of procedure, it's really difficult to get things in on appeal, but somehow it seems interventions are like the new wild card, where if you frame it properly as a reaction to the intervention, it's like an all-in approach. If you refile the submissions you made on appeal, the boards here say they really do not have any discretion. They have no legal basis to refuse it. So that's, we think, a really important potential consequence to keep in mind in this question of interventions during oppositions or appeals.
Right.
Okay. I think that really brings us to the close of this
15 minutes
session. Yeah, so sorry for taking over, but we see that a lot of you are still on. So thank you for bearing with us. And we will now end the official recording of the webinar, but feel free to still ask questions via the Q&A, or also if you want to raise your hand and enter into a face-to-face video or audio discussion with us, we can also do that now that the recording is stopped, to have a more informal conversation if there's anything that we presented that you would like to discuss. Otherwise, thank you very much for your attendance. Yeah.